For today's Toil and Trouble Employment Law slot, I'm joined by Charlotte Joy, a Senior Associate at B Employment Law, about vexatious employees and what an employer can do about them. This is a big issue for employers, isn't it?
It is, and it often occurs both when employees are still employed, working through a process, but also after employment when claims and litigation is brought.
You've raised the issue that, at the moment, people are probably a little bit more eager to keep their employment going or to keep the revenue stream going. Do you think there's a correlation with how many of these cases we see?
Definitely, particularly given the number of restructures we're seeing at the minute, even when an individual probably has the knowledge to know that there is really sound reasons for a restructure proposal. Often there is still, we're seeing recently, a big challenge to that. Which I think shows that people are a little bit more desperate.
Yeah. What is a vexatious employee?
So a vexatious employee is someone who does something when there isn't a reasonable basis for it. So, I mean, in a legal sense, then they are making complaints about a process or a dismissal or a redundancy, say, without a reasonable basis to base that on, or for an improper reason.
So wouldn't the law just reject such a thing, or why does it become more complicated?
It becomes complicated because the courts are always balancing the right to access justice and the courts versus the defendant's ability to defend a matter and not have to be subject to the costs of expensive litigation. So it is a very high threshold to throw out proceedings from the courts because of that balance.
Of course, this is what the ACT Party has said prior to the election, that it was going to reduce the numbers of vexatious complaints, personal grievances based on vexatious complaints. What did you make of them? Were they right in saying that the court is too often sort of siding with employees in these matters?
I think perhaps the focus for the ACT Party is more around the motives of the employee, and I think I think that because of the high threshold of salary that they are proposing, so it seems perhaps that their view is that because an employee earns so much, that that perhaps disentitles them to the normal recourse, or they should be more alive to issues that could create dismissal. So for me, I think it's more around the motives behind the individuals and their view that a high-earning individual perhaps will have other motives for bringing a claim because they are so well remunerated and shouldn't have the same issues of others of getting new employment.
Right. It seems like an odd argument to suggest that high-earning people shouldn't have the same access to justice.
It is, and that's why perhaps that the proposal isn't overly popular in some sectors.
Right. Interesting. So what is the most sort of common scenario that you might be approached with by an employer? I mean, obviously you can't talk about specific cases, but if you amalgamate what you see.
Sure. So during employment, we're commonly seeing people trying to slow down restructuring processes, saying that they need more information relating to a proposal or needing more time to give feedback. So that is really common. And then after dismissal, challenging those redundancies is a really common one. I think another quite common example is people contesting the process. So they might have been dismissed for a misconduct element, which they perhaps don't dispute, but they're challenging the way in which they were dismissed despite them being in the wrong.
So what can an employer do in the case of the first instance where people are trying to slow down a restructuring?
Be clear from the outset about your time frame. So it's all about communicate. Your expectations are clear. There is a degree of allowing an employee more time and acting in good faith if there are genuine questions. So I guess the best thing you can do in that sense is do all your work up front before you've even given the proposal to employees, because if you're anticipating the questions they might have, if you're providing that information, they shouldn't then need to ask the questions. And then once questions are asked, if it's clear that the information is already provided, you can be a little bit more bullish and move through that process. I think it's also worth keeping in mind when you're setting those firm timeframes that perhaps there may be an employee who gets advice and wants a little bit more time. So giving yourself that time from the outset is important.
Can an employee realistically challenge a redundancy process?
You can challenge the redundancy both on the substantive reason for that redundancy. So that means there being a hole in the rationale, so say the cost issue if that wasn't actually a reality, or you can also challenge the redundancy on the process. So where an employee isn't given all of the information to comment or not given an opportunity to comment before a decision is made.
So has there been a case where someone has challenged a redundancy on the first basis, saying it's not necessary, and won that case?
Absolutely, and there are a lot of cases where, unfortunately, improper motives of the employers come through at that point. You know, there's an argument that a redundancy needs to happen for cost saving, but then on the face of it, that cost saving wasn't a reality, and then there's other issues of perhaps performance concerns that cloud the decision.
It's amazing that employers still don't really, or not all employers seem to understand the necessity of being completely upfront, honest, and following their process very strictly.
Yeah, it's true. And that's honestly where most employers can avoid these vexatious claims, is by doing that work up front, being open and honest and communicative, consistent with good faith obligations, to try and avoid those claims during the process.
The term strikeout, how does that apply to this topic?
A strikeout can be applied for when there is a view that the claim is vexatious or frivolous. So in the first instance, if there's an improper purpose, if there's a number of claims that overlap, if there's claims against individuals who aren't actually the employer. In terms of a claim being frivolous, it's whether there is any reasonable basis in law for a claim to be made. So it's worth seeking advice to see whether a strikeout could be applied for.
We've heard a lot of commentary lately from politicians and other lobby groups that do say the employment authorities are moving towards being more liberal towards employees. I mean, is that the case? Is that what is happening here?
A lot of the cases that arise before the authority do seem to perhaps go the way of the employees. Part of that, I think, reflects the fact that there is a high bar on employers to follow strict processes when they're looking to dismiss employees, which is consistent with being fair and open. So it's a high threshold on them, which probably results in more cases being brought by employees.
But you don't think in general the courts are sort of changing the way they view these kind of things?
No, I mean, I think that they're just applying the strict principles they have in front of them and take a view that employment is a sacred element, I guess, of human life, and those principles must be strictly upheld.
Charlotte, thank you.
Thank you.
To support our award-winning independent journalism, subscribe to nbr.co.nz.